conferencia magistral intitulada May Constitutional Jurisdiction be Protected from the People in the Face of Populist Challenges, que será disertada por el doctor Stefan Kirste. Presenta esta conferencia la licenciada Cintia Martínez González, integrante del Centro de Investigaciones Judiciales de la Escuela Judicial del Estado de México, a quienes recibimos con un fuerte aplauso.
Cedemos el uso de la palabra a la licenciada Cintia Martínez González.
Muchas gracias, bienvenidos y bienvenidas a este segundo día del Congreso Internacional de Filosofía del Derecho, Jurisdicción sin Constitución. Sin duda, ayer escuchamos disertaciones muy interesantes de nuestros ponentes y no será la diferencia el día de hoy y el día de mañana. Bueno, para abrir este segundo día, entonces, recibimos al doctor Stefan Kirste, quien nos va a hablar de un tema fundamental, la democracia y el Estado del Derecho, la relación entre la política y el derecho en el ámbito constitucional. Nos va a hablar un poco sobre el fortalecimiento de la protección constitucional frente a los desafíos populistas, algo esencial para la defensa de los derechos de los ciudadanos y un buen funcionamiento de nuestras democracias. Me voy a permitir leer un poco de la semblanza del doctor. Él inició sus estudios en Derecho, Historia y Filosofía en las universidades de Ratisbona y Friburgo, en Alemania. En 1997 obtuvo el título de doctor en Derecho en la Universidad de Friburgo. En 2004 completó su habilitación en la Universidad de Heidelberg, también en Alemania. Entre los años 2004 y 2008 se desempeñó como profesor visitante en diversas universidades alemanas y en la Universidad de Virginia, en Estados Unidos. Posteriormente, en 2008 fue nombrado profesor de Derecho Público y Derecho Europeo en la Universidad Andrássy en Budapest. En el año 2012 recibió el nombramiento de profesor de Filosofía del Derecho en la Universidad de Salzburg, en Austria. En 2020 se incorporó como profesor colaborador en la Pontificia Universidad Católica de Río Grande do Sul, en Brasil. Desde 2001 ha sido profesor invitado en varias universidades brasileñas, llevando sus conocimientos y sus perspectivas a distintas generaciones de estudiantes y profesionales del derecho. Es un honor recibirlo el día de hoy. Por favor, un aplauso para el doctor. La conferencia será dictada en inglés, pero todos ustedes ya cuentan con el aparato para poder traducirla.
Good morning, everybody. Thank you very much for the invitation to come here. Thank you very much to Javier for inviting me, bringing me here to Mexico, to Toluca. I'm here for the first time. I'm impressed especially by this week, the festival that is going on, but I'm also impressed by this institution. So several reasons to be happy to have the chance to present some ideas about populism and constitutional courts, namely address the question if there should be a protection of the constitutional courts by constitutional amendments against populist threats. I was amazed by the introduction. It was so quick. I wondered whether German sounds so quick for Spanish-speaking people. I couldn't even follow. I only grasped a few names. So I will be speaking a bit slower, although I'm confident that the interpreter can follow, and if not, she'll indicate this to me. So as we can see around the globe, populists promise us to bring more democracy. They criticize not only this and that constitutional institution, but they criticize core aspects of our constitutional democracies. And this especially refers to constitutional courts. They are necessarily a necessary target of populists because from time to time, constitutional courts have to make unpopular decisions, unpopular judgments. So my thesis, which I'm going to defend today, well, you see most of it, will be that to the extent that constitutional jurisdiction is justified by the concept of law and democracy, it's also justified to safeguard it in constitutional law, especially in the Constitution itself. So I'm going to elaborate this thesis in 5 steps and come to a final conclusion. In the first step, I think for legal philosophers it's due to present some definitions of what we will be talking about, namely the concept of the justification of public authority and populism. Then I tell you a little bit or remind you a little bit about the threats imposed by populists on constitutional institutions. Then I specify this threat with regard to constitutional courts, speak about theoretical justifications for these populist constitutionalism, as some call it, and then finally discuss the democratic and substantive legitimation of constitutional courts. So let's come to the first chapter, if you want to, conceptual distinctions. The first concept I'm going to apply and work heavily on that, you remember from the thesis, I said constitutional protection of constitutional courts is legitimate, can be justified if the constitutional court itself is justified. Now, what does justification mean? Justification of public authority has 2 aspects. First of all, a procedural aspect, namely legitimation. Legitimation of public authority describes procedures of civil society in which justifying reasons for the existence of public authority are deliberated, expressed, and decided by all persons concerned of these decisions or by their representatives. So it's very important that this form of the justification of public authority is an input justification, an input legitimation. Legitimation by procedure. In contrast to this, but often in addition to the procedural aspect, we also have a substantive justification of public authority. I call this legitimacy. If you look at the literature, you will quite often find the 2 concepts confused. I sharply distinguish the 2. Legitimacy refers to substantive, functional, pragmatic, often economic reasons that can justify public authority. So sometimes politicians tell us you are better off by this and that policy. And therefore, they justify their political decisions by results. Whereas legitimation is, in philosophical terms, but I think this is 19th century political thinking. It treats the individual citizen only as a private bourgeois in the French term, an unpolitical citizen. And he may be happy, of course, but he is less happy than the citoyen, in Rousseau's words, the citoyen, the politically active citizen who can participate in the fundamental decision of politics. And the whole development of democratic theory concerns the transformation of the bourgeois, the private, autonomous citizen, into the citoyen. So we shouldn't follow theorists, I think, who tend to pacify us and tell us, be satisfied by the result. We can define populism if there's a common denominator for all forms of populism. But one thing should be clear: it is a certain form of communication that tries to achieve its goals by breaking up the dialectical, whatever this is, will be explained soon, dialectical connection between democracy and the rule of law principle, or the principle of the legal state. So it's a certain form of political communication we could call populism. Populism is not an ideology, because it is typical for populists to have an opportunistic perspective towards ideology. Cynthia mentioned that I taught in Hungary for a couple of years, and during the time Viktor Orban was elected president of Hungary. He changed his ideologies quicker than I could change my code. So there is no particular, often it can be a nationalist ideology behind populism, but not necessarily. So we also have right-wing and left-wing populism. I come to this point because this is contested as well. Populism can therefore be identified rather by a bundle of criterion than by a clear definition. So let's look at some of the criteria to identify populism. One, admittedly coming from a Hegelian perspective here, from the idealist philosopher Georg Wilhelm Friedrich Hegel, I think one of the characteristics of populism is the immediacy of their communication. So populists have strong convictions about what is true. And based on this, some of them underestimate the impact of sciences. They speak of felt truth. They seem to have what we in moral philosophy could call a strong cognitivism. They know what is right. They know what is wrong, even without public deliberation. And as Richard Nixon did, they refer to the silent majority. So the people don't have to deliberate. They don't have to communicate about what is good, what is bad. But the people know that, even though they are hindered from expressing it or cannot discuss it. They speak of strong identities. Their concept of a people is a primordial concept. It isn't, the people is not the result of communication, is not the result of participation in a public discourse. But the people is a historical, a cultural, language identity that is given and not a social construction. Unfortunately, coming from Austria, we just had a national election of the national parliament, and a populist won this election for the first time. We could have, in a profound democracy based on the theory of Hans Kelsen, we could have a populist being the chancellor of Austria. And he says he considers himself the tool of the people to realize their wishes. Now, a tool is something different than a representative. And this is typical for populist talk. They feel that they are the incarnation of the people, as Hugo Chavez in Venezuela once put it. The incarnation of the people. Their task is to immediately react on the will of the people. And therefore they claim to have a direct mandate. They refer not to a discussion, a public discussion of the goals of a populist party, but in a very vague understanding refer to the spirit of the people. There has been some confusion about the term populism because in the older American literature, there is a positive connotation of populism, namely Abraham Lincoln, and in particular in his Gettysburg Address, was considered a populist. Now this is confusing because it mixes popularity with populism. We do have and we need popular politicians, politicians who are capable of explaining the goals, the means, the instruments of their politics to the people. This would be popular. What distinguishes them from populists is that populists oversimplify their arguments. Another characteristic of populists is, and now mind the term, media, the use of media. Media is not considered as a source of mediation of public discourse, but thought of as a weapon. And if you think of Elon Musk and Twitter, it is quite apparent how social media are used as weapons, not as fora for a pluralistic discourse. Another aspect, and I only mentioned a few, are static preferences, non-institutional forms of communication. So supposedly, the populists use grassroots forms of initiatives. They speak of movements in Hannah Arendt's critical sense. They advocate plebiscitary decision-making, And as I said with the Austrian example, I already mentioned this, they claim to have a direct mandate and don't feel themselves as representatives. Apart from these procedural aspects of populism, we can identify some structural aspects. And the most famous one is by Jan Werner Müller, was discovered by Jan Werner Müller, the pars pro toto argument. Although populist parties are only parties amongst others, they consider themselves as the sole representative or the sole incarnation of the people, the incarnation of the true people. So they mix the notion that they are only representing maybe a majority with the identity of the people. And to express this, they excessively use the national anthems, the national symbols, the national anthem, but also the national flag. So I remember in Brazil, when in the campaign of Bolsonaro, in his first campaign, you couldn't use the green wonderful flag anymore because it was instrumentalized by Bolsonaro, claiming that he would be the people, the Brazilian people, although he was only the head of a coalition of parties. Then, under the topic of exclusivity and strong identity falls xenophobia, homophobia, misogyny, in some cases tragic, disregard, especially in right-wing populism, disregard discrimination of women, although the women they discriminate against vote for these populists. Strong integration of the leaders, and another very important characteristic is they have the notion that we know the truth and the others are not our adversaries, are not our partners in public deliberation, in public communication, but they are our foes. So they distinguish clearly between good and evil, and they know what is good, between citizens and strangers, friends and enemies, subjects and rulers, we and the establishment. So an anti-elitist notion is also characteristic for many populist movements, whatever the elite is. And sometimes, and often, populist politicians are part of the elite, pretending not to belong to them, but to find their real identity as part of the people. Populists, based on these characteristics, populists criticize, they have a negative attitude, they express especially their criticism. And this criticism refers to the separation of powers, the limitation of powers by individual rights, and the formal structures and institutions of the rule of law. They motivate, drive their followers by fear, and impose themselves a threat to legal security. If they are successful and elected into power, they put into question the political institutions. They criticize the statics of the Constitution and advocate an ongoing activism. So they move towards a presentistic, one could call it presentistic political activism. Courts are standing in the way of this activism. From the general notion, courts are past-oriented, the legislator is future-oriented, and the executive is is enacting the political goals that were set in the legislation now. So populism often leads to an increase, to an blow up of the executive power in the system of the separation of powers. And you can see from this that populists pose a general threat to constitutional democracies. And it's not quite easy to identify in how far and in what sense they impose this threat to constitutional democracy. Because during the campaign, you often hear the populists saying, "We bring you more democracy. We help you stand up against the financial, the economic, the judicial, the intellectual elite. We give you voice." So isn't that positive? To get voice? But is that really the case? And how would they give voice to us? They would give voice to us by criticizing the legal institutions. They put closed discourses on the position of open and public discourses. One of the great achievements of enlightened philosophy preparing democracies in Europe and the Republic in Mexico was that it is necessary for political decisions to discuss your arguments in the light of public. Populists work with the darknet, with private chat rooms, filter bubbles, and the like. So instead of the process of refining and forming of public opinion, you have self-confirming fora in social media that cannot produce the reasons that will be the basis for the public legitimation of public authority. Remember, we spoke of procedural legitimation and substantive legitimacy. If the reasons for public decisions, policy decisions, are debated only in private media or private social media, then it is difficult to produce public reasons that are valid not only for those who participate in these private chat rooms, but for all the people. In order to produce legitimation of reasons for all people, you have to have discussions, open discussions by all people. And this brings me to the fourth remark here. Why is the claim of populists that they would bring us more democracy wrong? It is wrong because democracy is dependent on legal institutions. A working democracy depends on individual rights, negative rights, to be left alone, to have privacy, communicative rights, the right to form an opinion, to express an opinion, or as the American Constitution says, the freedom of speech, to associate in associations, but also in political parties, and ultimately to have an equal participation in the ballots, in the political decisions. This all needs to be protected by individual rights, by human rights, by fundamental rights. So these fundamental rights not only have the negative dimension with which the populists could well live, but they also have a positive dimension. I not only have the freedom to be left alone, but as a citizen, I also have the freedom to participate in the political discourse. And both dimensions need to be protected, and for this protection, you need legal institutions. The people is not a given entity. Maybe in 19th century national states, one could refer to homogeneous history of the people, of a given people, the German people. But this is not the case in states in a global society. If we want it or not, we are all pluralistic, multicultural societies in which the forming of an identity is a construction. And to suggest or to claim that a people is there is a Mexican people, is underestimating the need for public discourses, for public communication in the forming of the we to which all people can agree. And this process is a process of mutual recognition of the citizens. The sovereign, finally, is not a uniform institution. Not only to split the power and make the government not too powerful, but in order to form rational institutions that administer government. Most modern constitutions institute the separation of powers. So if populists promise to give us more democracy, but at the same time threaten the institutions necessary for democracy, it is clear that after the election we will have less democracy by those who promised us more. Now, my main topic, of course, is the position of Supreme or constitutional courts in this discussion. Andrew Arato, a Hungarian American political scientist, writes, in this populist struggle against enemies, from Perón to Indira Gandhi, from Fujimori to Orban, the one constant is the attack against independent apex court that fully ceases only when such a body entirely loses its independence. And the ability to act independently, an important sign of the emergence of a populist regime. And my German colleague, Dieter Grimm, former judge of the German Federal Constitutional Court and highly regarded constitutional scholar, said, Verfassungsgerichte sind das erste Opfer der Populisten. Constitutional courts are the first victim of populists. And if we look at Hungary, if we look at Poland, and if we look at several other countries, it is quite apparent that this is the case. Now, to show you the threats imposed by populists on constitutional courts, I distinguish between external and internal threats. I was, after Orban was elected, I was impressed. Orban, the first Orban in the beginning of the millennium, was a liberal, okay, and he promised not only more democracy, but also to do something for the Constitutional Court of Hungary. And this court had the highest authority, not only political legal authority, but moral authority, because the transformation of the Hungarian legal order from a communist constitution to a pluralistic constitutional democratic constitution was in many senses brought forward by the jurisdiction of the Hungarian Constitutional Court. Now Orban said, I'll do something for these poor judges in the Constitutional Court. They have so much work to do. And they did a lot of work. So I retire the highly regarded judges a little earlier. They can enjoy their pension. And I enlarge the number of judges at the court. Well, nice. But the idea is obvious. The court loses and in fact lost its independence. Because naturally, or in the Hungarian constitution, the president chooses the judges. So he chose judges from the ultra-conservative, nationalist, populist party Fidesz. So from this moment on, 2011, 12, 13, the Constitutional Court in Hungary was never in his way stopping his political populism. So we call this court hacking. Oh, remember the final month of the Obama government? Obama wanted to appoint a judge. It's his constitutional right. But Mitch McConnell, leader of the Republicans, said, no, this is undemocratic. If in your final month you appoint a new judge, this is undemocratic. Obama gave in, and the new judge was appointed by Donald Trump. When the same happened, shortly before Trump was elected out of office, this principle was fully forgotten. And another conservative judge was appointed then. So now we have a conservative majority in the US Supreme Court. We call this court hacking. There are different forms of individual influences of politicians on constitutional courts. Others are forms of impeachments. Boris Yeltsin in Russia had used this mechanism to make the Constitutional Court, also high authority at the time, quiet. Disciplinary measures in Hungary, in Poland, they institutionalized a disciplinary chamber with members of the ruling peace parties, disciplining the members of the Constitutional Court. Another mechanism is a change of the range of jurisdiction of courts. Should constitutional or Supreme Courts only decide about disputes between the constitutional institutions? Should there be a general review of laws? And in many cases, populists decide against against the right of constitutional courts to review acts of the legislator. The tricky point is here that not only populists criticize judicial review. We'll come to this point in a minute. Another mechanism to infringe the independence of constitutional court could be to override the rulings of the Constitutional Court. So if the Constitutional Court calls a certain law void, the Parliament may overrule this decision by a certain majority. So this would give the last word on the constitutionality of laws to the Parliament. Some of these aspects, as I said before, are not roundabout problematic, taken by themselves, but in combination, they threaten the independence of constitutional courts and thereby threaten the rationality these courts can develop. Other mechanisms to infringe the competencies of the court would be constitutional amendments. I'm going to come to this later. Apart from these external elements, external threats to constitutional courts, we could mention, I found that quite interesting and quite interesting aspect in an article by Bernstein and Stasevsky, professors from the University of California. They speak of judicial populism from inside the Supreme Courts, from inside the constitutional courts. Let me quote what they are writing here, how they summarize this judicial populism. Judicial populism uses political populism's tropes, mirrors its traits, and enables its practices. Like political populism, judicial populism insists that there are clear, correct answers to complex, debatable problems. It disparages the mediation and negotiation that characterizes democratic institutions and rejects the messiness inherent in a pluralistic democracy. Instead, this judicial populism simplifies the issues legal institutions address and claim special access to a true single meaning of law. As lawyers, we should be skeptical if someone tells us laws would have a single precise meaning. So judicial populism is populism practiced by the constitutional justices themselves, by the Supreme Court justices themselves. And in their extensive article, Bernstein and Stasevsky give a long list of examples from American justices who apply the methods of populism in their legal argumentation. On the forefront of this judicial populism is the question of textualism. Does constitutional interpretation only have the task to find out about the original meaning of the words used in a constitution? Are they limited by the verbal interpretation of the Constitution? Now, we all know that in the past 30, 40 years, or maybe even 50 years, with the change of the function of fundamental rights from merely negative liberal rights to social welfare state rights, positive rights to certain subsidies, the interpretation of fundamental rights has also changed. And as one of my Freiburg teacher, Konrad Hesse, said, necessarily has to change. We can't stop with the wording. We cannot limit the interpretation of the Constitution to the interpretation of the wording of the Constitution. Admittedly, this gives constitutional judges a certain leeway, enlarges their competences. Now, both of these, I've called them threats to constitutional courts, are justified if you look into the legal and political literature about Supreme Courts and about populism. We have, of course, the left-wing justification of left-wing populism. Claude Lefort, Chantal Mouffe, ultimately based on Carl Schmitt, they advocate populism by saying that populism opens the closed space of political discussions, of politics, enabling again the people to make sovereign use of their political self-determination. They justify the anti-elitist notion of populists. But not only from rather left-wing political theorists comes a justification of populism. If we look at the position of constitutional courts, we have also liberal justification of populism in both sense, both populists claiming or demanding a limitation of the powers of the constitutional courts, but also populism from within the courts. Mark Tushnet, for example, writes, "Return all constitutional decision-making to the people acting politically." And then there's a mistake in the slide, but we continue. "We all ought to participate in creating constitutional law through our actions and politics." So constitutional interpretation is not merely a task for legal professionals called justices of the Supreme Court, but it's our task as people. Continuously, we have to interpret, concretize the Constitution. And Mark Tushnet concentrated his, or focused his theory in saying that take away the law from the courts. Take away not only the laws in general, but also the Constitution in particular. And then another constitutional theorist, constitutional scholar, a German, Ernst Wolfgang Böckenförde, also from Freiburg, Böckenförde, he says that by self-empowering, constitutional courts have become a superpower, superior over all the other powers. And this was not meant when most of the constitutions were drafted. Think of Marbury versus Madison. Marbury versus Madison is a judgment was a judgment in 1803 by the US Supreme Court, self-empowering certain or giving certain competences to the Supreme Court, namely a judicial review of laws and the acts of other institutions. So isn't the Constitutional Court self-empowering? Isn't it making himself, or aren't the Supreme and Constitutional Courts making themselves superpowers in the separation of powers? And other forms of critique come from rather conservative approaches, methodological approaches. Justice Scalia and also a legal scholar, Scalia, he claimed that the self-empowering was done by the methods of interpretation. In taking individual rights, not only as negative rights, but as objective principles. The German Federal Constitutional Court speaks of a hierarchy of constitutional values expressed by fundamental rights. This enlarges the competences of the courts and thereby methodologically enabling them to take tasks they were not given in the Constitution. So I received a note that I should be quick, and I will do so. Now, what is the legitimation of these courts, Supreme and constitutional courts. First of all, I think in the American world, you would speak of the principle of the rule of law. In the German speaking world, we speak of Rechtsstaatprinzip, the principle of the legal state. The concept of law, first of all, argues in favor of constitutional and other courts, and argues in favor of their independence. Independence is not meant to make them, to relieve them from responsibility, but to enable an independent rationality in dealing with constitutional questions. Individual rights, especially communicative rights, are, as I said before, preconditions for the political process. And the Constitutional Court has the ultimate task to observe the adherence of these individual communicative rights to enable democracy. So the constitutional courts not only have a function for the rule of law, but also for democracy. And finally, the sovereign itself has spoken. The people have spoken by drafting a constitution, by enacting a constitution. This enactment of a constitution is in the precise sense an act of the self-determination of the people, an act of political autonomy, if you take the Greek root of the word autonomy, a self-given law. And if you read Hamilton's interpretation of the necessity of a constitution in the Federalist Papers, number 78, he's very well aware of this. The people, the sovereign, has given themselves a constitution as a superior law. And all the other powers have only delegated powers from this constitution. So the Supreme Court also has delegated power, but the Supreme Court or the Constitutional Court has the power to observe the adherence of the Constitution, to observe or decide about the question whether a law is constitutional or not. And the tricky question, of course, and this is a question you in Mexico are dealing with right now, and I'm afraid I won't have a clear answer to this, is the election process of the judges of constitutional or Supreme Court. This is not a trivial question, and it's not merely a question of the self-determination of the people. It is a question of how we frame the recruitment of the experts in the Constitutional Court who then have to decide the constitutional questions. How can we shape the recruitment in a way that the institution can develop its own rationality? And for this process, we have to find institutions procedurally legitimizing the judges who have an understanding for the necessity of an independent legal rationality. The Constitutional Court is not only one power amongst others, the president or the executive and the legislator. It is a power with a particular rationality. And in the case of the Constitutional Court, this rationality delimits politics from law. So the recruitment of the judges of this institution should be shaped in a way that the persons elected guarantee the independence, guarantee the development of the rationality. So to come to my conclusion, I had a bit brief in the end. It is justified to amend the Constitution in a way that protects the independence of constitutional courts, because this independence ultimately guarantees both democracy and the rule of law. This does not mean, however, that criticism of the range of the jurisdiction of constitutional court couldn't be legitimate. That does not say that we could think of alternative mechanisms of, let's say, internal review of laws. Jürgen Habermas has suggested that there should be an internal self-control of the parliament. Now, I'm not sure how to institutionalize this. I mean, if you have made a decision, you know that your decision is right. Okay, and then you review your decision, and surprisingly, you still have the conviction it is still right. And apart from this polemic argument, neutrality of the Constitutional Court secures not only independence, but avoids partisanship. Parliament is a political institution where power decisions are being made by majorities. Constitutional courts, with respect to individual rights, are there to protect the rights of minorities, of individuals. This is the reason why they should be independent. This is the reason why they should develop a legal rationality. And I'm afraid that a parliamentary self-control couldn't do this job. So to sum up, I would say that prior to populist governments, it is necessary and justified to amend the Constitution in a way that protects the functioning of constitutional court. Because without constitutional courts, political decisions will lack either democratic legitimation or substantive legitimacy, or both. Thank you very much for your attention. And I'd like to particularly thank my interpreter who helped that you could understand what I was trying to tell you. Thank you very much.
Muchísimas gracias al doctor Stefan Kirste. Sin duda, muy interesante, nos resuena en el contexto actual mexicano todo lo que nos dijo, es familiar para nosotros y nos deja con una pregunta al final que nos hemos estado haciendo y debemos continuar haciéndonos respecto a las reformas al Poder Judicial. Por cuestión de tiempo tenemos espacio para una pregunta, tenemos también a la traductora para que no se preocupen. De este lado, por favor.
Well, I want to start. I want to start by saying, by expressing my deep admiration, and I found your conference extremely interesting, since you pointed out different elements and different concepts I never thought of. It really helped me to expand my knowledge and, change my perspective. But I digress. I would like to know what specific mechanism can constitutional courts employ in order to safeguard democracy against populist threats, and what roles does civil society play in supporting judicial resistance in populism? Thank you.
Yeah, very, very important question. And also one could speak for at least half an hour. It is quite clear that the authority of the Constitutional Court rests on the quality of their arguments. First, but also on civil society. And I forgot which Barbosa it was, but, the constitutional judge who also teaches at the UERJ in Rio de Janeiro. He said it is more difficult for populists to overturn a constitutional court who is deeply respected in civil society. And this puts a great responsibility on the court, but also on the media. The court has the very difficult task to, on the one side, argue based on legal methods, which are highly technical. We all know this as lawyers. But at the same time, present their arguments in a way that is convincing to civil society. The people really understand the basic reasoning of the judgments of these courts. And I just spoke to a Supreme Court, a judge in Germany, a criminal court a judge, and she said, arguing for our decision was quite easy, but defending the argument in public, that was the tricky part. And it often is. It could help that public TV reports maybe on the deliberation, but at least on the promulgation of the decision. It is important that in a rational way, the media discusses the judgments, pros and cons, so that we don't get the expression there are, in some cases, 12, 13 wise old men deciding about our issues, but to make this process of deliberating in the court transparent, not only for the people to reconstruct the reasoning of the decision, but also for future decisions and also for demands people have towards politics. So this shows that the status and the stability of the Supreme or Constitutional Courts massively depends upon the recognition of the courts in society. This again depends on the quality of the decision and the influence of media in transporting the messages of these courts. I hope I answered your question.
Agradecemos la brillante participación de nuestro conferencista. A continuación, la licenciada Cintia Martínez González hace entrega de un muy merecido reconocimiento al doctor Stefan Kirst por su destacada disertación.